Hello, my name is Meredith Block. I am a staff attorney at Neighbors Link, and I'm here to speak to you today about citizenship and naturalization. First of all, many people ask why it's important to become a U.S. citizen. Citizenship can protect you from deportation. It can confer citizenship to your children who are under 18. It can help you to reunify your family. It can make you eligible for government jobs. It can afford you the freedom to travel as you like. And very importantly, it confers the right to vote. There are several ways of obtaining U.S. citizenship. First of all, for those born on U.S. soil, you automatically become citizens. This includes those born in U.S. territories, and it does not matter what status your parents have. You can also acquire citizenship at birth if your parents are U.S. citizens, or even in some cases if your grandparents were U.S. citizens. You can derive citizenship from your parents after you're born in certain situations. And as an adult, you can become a U.S. citizen through the naturalization process. Naturalization is the process by which a foreign national can become a U.S. citizen. Before you apply, you need to rule out that you have not already become a U.S. citizen through acquisition or derivation of citizenship. These are the general requirements for becoming a U.S. citizen. To naturalize, you must be a lawful permanent resident or an LPR. You must be at least 18 years old. You must meet certain continuous residence and physical presence requirements. You must be a person of good moral character, speak, write, and read basic English. You have to pass a test of U.S. history and government or civics. And you have to take an oath of allegiance to the United States. I'll go through each of these requirements one by one. First, when can you apply to be a citizen? You can generally apply after having been an LPR or a resident for 5 years. However, if you are the spouse of a U.S. citizen and you continuously resided in the United States for 3 years, then you can apply after those 3 years. Your spouse must be a U.S. citizen for the entire time, the entire 3 years, and you have to be living with the same United States citizen spouse, even up to the time of the oath. If you obtained your green card through VAWA, because you were the battered spouse of a U.S. citizen, or child of a U.S. citizen, you only need to wait 3 years. And in some cases, you can become a citizen after 1 year for members or veterans of the U.S. military. Everyone else needs to wait 5 years after becoming an LPR in order to apply for naturalization. So to prove continuous residence, either for the 3-year or the 5-year period, you have to remember that you need to spend over half of that period in the United States. So, for example, you need to spend over 2.5 years in the United States if the 5-year continuous residence applies to you. And if you are outside of the United States for 1 year, that will break that period, and you will need to start the 5 years again. If you're outside the United States for more than 6 months, but less than 1 year, it could break that continuous residence period. And in that case, the USCIS will look at these factors to determine if you actually did break your continuous residence. Long absences of more than 6 months can create a presumption that the green card holder abandoned their residence and could trigger deportation proceedings. So if you've been outside the United States for more than 6 months and you're a green card holder, you should consult with an attorney before you apply for citizenship. As I mentioned, you must have been physically present in the United States for half of the 5-year period, so 30 months of the last 60 months, or 18 months of the last 36 months. And you also have had to have resided in the district or state where applying for naturalization for at least 3 months. So if you want to apply in New York, you have to have resided in New York for at least the past 3 months. You also will have to take a civics test and an English test. For the English test, you must understand English. You must be able to read, write, and understand and speak English. You have to be able to read one of 3 sentences and write one of 3 sentences. However, there are exceptions, which I'll go into later, for those people who are elderly and who have been green card holders for their 15 or 20 years. As for the civics test, you must know fundamentals of history and form, and the form of the U.S. government, and you will be asked 10 questions, and you must answer 6 questions correctly. For both tests, if you have a disability, you can receive a waiver so that you do not have to take those tests. And depending on what your disability is, you can forego either the English or the civics test. And you should also speak to an attorney so you can fill out the N648 to receive that dispensation. These are some of the questions on the civics test. So for example, what is the supreme law of the land? Who is in charge of the executive branch? And all of the questions are available at this link in English and in Spanish if you want to review them. So as I mentioned, certain green card holders who have been here for a long time do not have to take the English language test. If you are over 50 and you've been here for you've been a green card holder for at least 20 years, you don't have to take the English test. And if you're 55 years old and you've been a green card holder for at least 15 years, then the same dispensation applies. If you're over 65 and you've been an LPR for 20 years, you receive a simpler civics test, and you do not have to take the English test. So this slide discusses how you would get that disability waiver that I mentioned, that form N648. It has to be signed by a physician or a psychologist to waive the English and civics exams, and it has to be recent. It must demonstrate how your disability affects your ability to learn English or the civics. Dementia or the effects of a stroke, for example, can be a reason that you would not be able to learn English or the civics, but old age alone is not enough. These doctors who will fill out this form can also consider learning disabilities, psychological disorders, a whole host of diseases. In order to naturalize, you also have to prove your good moral character, and you have to show that you have been, you've been a person of good moral character, and that during the 5-year period right before you apply for your citizenship, you had good moral character. That good moral character has to extend until the time you take your oath of allegiance and formally become a U.S. citizen. Conduct prior to the 5-year period may, in certain circumstances, be considered, and so if you have arrests or criminal history, you should also consult with an attorney. Any contact with the criminal justice system is taken into consideration, as is child support, whether you've paid child support, taxes, whether you paid taxes, whether you signed up for selective service, voting issues, if you may have voted and you were not authorized to do so, and then marriage and children. You must take an oath to the United States in order to become a citizen. If your disability makes it impossible to understand the oath, there may be a modification of that oath. If you're religious or you have a conscientious objection to war, to signing up to bear arms on behalf of the United States, you can include a letter from a religious organization documenting your sincere belief. So now I'm going to discuss how you would go about applying for naturalization. You have to fill out the form that is required, which is the N400. You have to submit a copy of the front and the back of your green card and supplemental documents in some cases. For example, if you're applying as a spouse of a U.S. citizen, and so you only need to have been a resident for 3 years, Then you need to submit proof of the marriage and the fact that you're still living in marital union. You must include copies of certificates of decision for all arrests and citations. And the regular fee to apply that you have to send with your application is $725. You can request a fee waiver if you make under 150% of the poverty guidelines, or a reduced fee if you're under 200%. However, USCIS is proposing to increase the naturalization fees to $1,255, and they're also proposing to eliminate fee waivers. It is not completely clear when this fee will increase will occur, and so if you're eligible for naturalization now, you should try to contact an attorney and to apply in order to avoid the fee increases. So what happens after you submit your form 400 and the fee? USCIS will issue a receipt notice and biometrics notice. And then there will be an interview, usually 6 to 9 months after filing. However, the current processing times are 12 to 28 months. Things are taking much, much longer than they used to. At the interview, you will have to do the English and civics test. You will review the N400 to make any changes if you need to update anything, and then you should bring all original documents with you. The officer could either make a decision then and there, or could request additional evidence. Some cases do get held up in security or background checks and could take even longer than 28 months. So if you're approved, you will receive a notice for an oath ceremony, and that is when you officially become a U.S. citizen. And you can also choose when you're applying for citizenship if you want to change your name, and your name change will become effective at the oath ceremony. So you must disclose any changes at the time of the oath of anything that has changed as far as your children, marriages, name, anything like that. And then if you have been arrested in between the time of your interview and the oath, you should speak to an attorney because it may affect your eligibility for citizenship, even though you've already had the interview. Shortly after the ceremony, you'll receive your certificate of citizenship, which you use the physical document that shows you're a U.S. citizen. And then in some places, you'll have to surrender your green card. So what is happening with citizenship naturalization applications due to COVID? Well, USCIS has suspended all oath ceremonies and all biometrics appointments since March 18th, 2020, until at least June 4th. As for biometrics, as soon as USCIS opens again, they will automatically reschedule people who have missed their biometrics appointments. In some cases, they are using previously captured biometrics if they're ready to adjudicate the application, but the only thing they're waiting for are the new biometrics. And the person already has biometrics done by USCIS, and the biometrics were used for the same file number, name, and date of birth. If your oath ceremony has been scheduled, it will also be rescheduled, and you'll receive a new notice in the mail. However, in some limited circumstances, USCIS may be able to perform small ceremonies for a limited number of applicants if precautions are taken. But those who are waiting for a name change will have to wait for a judicial ceremony. That's all I had to share with you today about naturalization. Thank you so much for your time. I hope it was helpful.